everyone, I hope you're well. I woke up this morning and was planning on filming an entirely different video from what I'm about to film. I was calmly sipping on my coffee until I saw this. Disney had finally responded to Scarlett Johansson's complaint, and so this is what we're gonna look into today. If you don't know what I'm talking about, or if you don't know exactly why Scarlett Johansson is suing Disney, pause this video. You can come back to it later, and I suggest you go check out my previous video about the Scarlett Johansson and Disney case. I'm gonna link to it somewhere here. I'm also gonna link to it in the description. Go watch that video first. Come back once you're done. If you're new here, hi, my name is Aisha. I am a lawyer and entrepreneur based in Montreal, Canada, and I make videos about productivity, how to become a lawyer, going to law school, and sometimes I break down situations just like this one. Now, today, as I'm filming this video, it is Saturday, the 21st of August. This motion was filed yesterday, so I'm relatively early, and simply put, this is a motion to move this case to arbitration. So soon after we learned that Johansson was suing Disney, Eric Gartner, who is Hollywood Reporter's legal editor at large, had actually predicted that this was going to be Disney's exact move, so that they were going to ask for this case to be moved to arbitration because Scarjo Johansson must have had an arbitration clause in her contract, and that is exactly what she had. So in their motion, Disney claimed that Marvel and Johansson had agreed that all claims, controversies, or disputes arising out of, in connection with, or relating to the agreement, the performance, or breach thereof, or the fault hereunder, whether based on contract, tort, or statute, shall be resolved by binding arbitration in New York, New York. They further specified the agreement would be governed by the laws of the United States and of the internal laws of the state of New York. So before going any further, what is arbitration anyways? So arbitration is a form of alternative dispute resolution. And with alternative dispute resolution methods, basically we're trying to avoid the courts for a variety of reasons. One, because a lot of times it's a lot more efficient. We all know that courts move very, very slowly. It can be cheaper than going to court. It's not always cheaper, but sometimes it can be cheaper than actually bringing a case to court. And with arbitration, it's really similar to going to court in the sense that you have an arbitrator who acts kind of like a judge and who listens to both parties and eventually makes a decision. Now, I said a few seconds ago that alternative dispute resolution methods, we're going to call them ADR for the rest of this video, that ADR methods had a lot of advantages. But one of the reasons why many companies like Disney favor methods like arbitration is because arbitration is private. When a celebrity sues a big company like Disney, it's usually very big news, not because it doesn't happen often, but simply because we never know about it because it usually goes to arbitration. And we all know that big companies really like discretion, so arbitration is a really convenient way for them to solve their matters. And this leads to another question. Why would Johansson bring this to court if she knew that she had an arbitration clause in her agreement? So aside from the fact that Johansson probably thought that suing Disney would bring a lot of public attention and a lot of pressure to Disney, which is what Disney suspects, and they actually mentioned this in their motion. Let's not forget that Johansson's contract isn't with Disney, it's with Marvel. The arbitration clause is in Johansson's contract with Marvel. Disney actually addresses this in their motion by saying that not being a signatory is not good enough of a reason to avoid arbitration. They further claim that a signatory like Periwinkle, which is the company through which Johansson offers her services, to an agreement containing an arbitration clause may be compelled to arbitrate its claim against a non-signatory like Disney when the relevant causes of action rely on and presume the existence of the contract. And according to Disney, this is exactly the case. Like, Johansson's claims entirely rely on the fact that Marvel released Black Widow on Disney Plus Premier Access and in theaters simultaneously. In regards to arbitration, Disney also says that federal law typically favors the respect of arbitration clauses, and also that the language used in the agreement clearly encompasses the dispute between Johansson and Disney, even if Disney isn't a signatory to their agreement. So while the majority of the points that are brought up in this motion are in regards to arbitration, Disney does respond to some of the claims that Johansson made in her complaint. If you guys remember, in Johansson's complaint, a lot of her claims turned around the the definition of a wide theatrical release. She said that a wide theatrical release means an exclusive wide theatrical release because everyone in the industry knows that that is what it means. Now, Disney, as many of you anticipated, answered that the contract did not in any way, shape, or form mention an exclusive theatrical release, and that actually the terms wide theatrical release were very clearly defined in the agreement. According to Disney, the contract also included consultation in good faith with Johansson concerning the initial release pattern, but that Marvel's decision would be final. Disney also took this argument as an opportunity to say that they had surpassed what was promised in the agreement. The term wide theatrical release was defined in the agreement as a release on no less than 1,500 screens. Disney says that Black Widow had debuted on 9,600 screens in the US and 30,000 screens worldwide. So clearly more than what was in the agreement. When it comes to compensation, we remember that Johansson had said that she had missed out on some very important bonuses because the release ended up not being an exclusive theatrical release. Now, Disney responds that one, the contract clearly said that Marvel could offer no representation when it comes to the box office receipts that the movie could actually generate, and that the hybrid release, considering the fact that the release was during a pandemic, was actually the best decision that they could make, not only for the success of the movie, but also for every single person that was involved in making Black Widow. Now, let's talk about the receipts from Premiere Access. If you guys remember correctly, when Johansson filed her complaint, Disney put out a statement saying that Johansson did in fact receive a portion of receipts from Premiere Access, and this is something that they bring up once again in the motion. They claim that Marvel had assured Johansson that those receipts would be used to calculate her additional compensation that was based on box office thresholds. And of course, thanks to Disney, we have some numbers. So in her complaint, Johansson talked a lot about how poorly Black Widow did during the opening weekend because of the hybrid release. But according to Disney, if you take the domestic box office total, which are about 80 million, and then the Premiere Access receipts for the opening weekend, which are 55 million, we're talking about more than 135 million for the opening weekend, which is more than a lot of Marvel movies like Guardians of the Galaxy, as well as other movies that are mentioned in Disney's motion. So to summarize, Disney wants this to go to arbitration. They say that a wide theatrical release did not mean an exclusive theatrical release. They claim that Johansson actually made quite a bit of money with the hybrid release and that she did get receipts from Disney Plus Premiere Access. Oh, and one other thing. They also mention in the motion that on August 12th, they reached out to Johansson's team to go to arbitration, and that request ended up not being accepted by Johansson. So what's next? We now see if the courts are going to decide to move this to arbitration. Interestingly enough, this is not the first time that Johansson's lawyer tries to go around an arbitration clause. This exact tactic was used when the team behind Bones, the TV show, decided to sue Fox in relation to some licenses that were granted to Hulu. It did end up going to arbitration, and if you're interested in reading about that, I will put some link in the description. Also, many people, including myself, thought that maybe we were going to see other lawsuits from other Disney stars. For instance, there were a lot of rumors going on about how Emma Stone and Emily Blunt could probably sue Disney for similar reasons. Now, we learned very recently that Emma Stone was able to renegotiate her contract and that there will be a Cruella 2. Obviously, the Scarlett Johansson case certainly served as leverage for Emma Stone in order to allow her to negotiate well, because obviously Disney did not want another lawsuit. But I'm really looking forward to seeing how all of this is going to end up. So what do you guys think? Do you think this is going to go to arbitration? Do you think courts will decide that Scarlett Johansson's team is actually right and that this case should be heard by the courts? Let me know what you guys think in the comments below. That is it for me. If there's anything else that you would like me to make a video about, just let me know. If you like this video, give it a thumbs up. Don't forget to subscribe, and I will see you guys very soon. Bye!